Hello everyone, this is MAHEK, a legal internet LEXIS and company. Welcome back to our channel. In this video, we'll be discussing how a state can exercise its jurisdiction in the international domain. So, first, before beginning, we'll discuss what does this word state jurisdiction means. The word jurisdiction is made up of two words, the juris and the diction. Juris means the law and diction means how we talk about it, means how much we talk about the law. So state jurisdiction means how to what extent the domestic laws of that state are applicable. These laws are the state jurisdiction is one of the central feature of the state's sovereignty. It's the ability of a state to apply its own laws over the international domain. So state can exercise its jurisdiction in four ways. First, by applying territorial principle, then is the nationality principle, then we have a universality principle, and in the last we have this protective principle. We'll be discussing all these principles one by one. First one is territorial principle. Under this principle, if a wrong has been committed within the territory of a state, then the state would have a claim to exercise its jurisdiction and to punish the committer of that wrong. For example, if a citizen of Nepal committed a wrong within the territory of USA, so the USA can claim jurisdiction over that person who had committed the wrong. The nature of this territorial sovereignty was discussed at length in the case of Lotus case by ICJ. In that case, it was held that the territorial if a case has been committed within the territorial limits of a particular state, then that state would have a jurisdiction to exercise against the offender of the wrong. Then the territorial jurisdiction, it can be subdivided into two parts. First one is subjective jurisdiction, other one is objective jurisdiction. Under the subjective territorial principle, we have if a state began in one state and it ends in some other state, then all these intervening states within which the one or the other part of that offense has been committed, those all states would have a claim to exercise their jurisdiction or to proceed with the proceedings against that tribe. For example, if a person had started smuggling gold from this country A, then he had visited company B, then C, then D, then lastly F. And final the offense was completed to the country F. All the countries A, B, C, D, and E, and F respectively would have a claim against that person because in all these states the wrong have been committed. This is the subjective principle of territorial jurisdiction. Then we have objective principle. Objective principle is very simple. It's just stated if any of the four elements constituting a criminal offense has been committed within the territory of a particular state, then the state would have a claim against that person, even if the offense has not been completed within the state. What are those four elements constituting elements of a crime? First one is the intention. Then we have this actus reus, mean action. Then we have a particular individual, human being, Then we have the injury. Means if a person had created his intention within a country, or had done any action related to the offense in the country, or the offense has been committed with respect to a individual of the state, or the injury has been caused to one some of the person. If any of those four or more than one of those elements are satisfied, then the state do have a claim against that person. Now we have nationality principle. Nationality principle is also a sub branch of this territorial jurisdiction. It says that if a person having nationality of a particular state is in the territory of some other state where the offense has been committed against him, then the state to which he belongs, of whom he have a nationality, the state can take actions against the person who had committed the wrong on the foreign soil against the citizen of that person of that state. For example, if A having nationality of India resides in France, and one of those French person has committed a wrong against A, then India can claim jurisdiction, and hence can have actions against that French person who had done the wrong with respect to the citizen of India, that A. So it is also nationality principle. These both are the examples of territorial jurisdiction, and these both are the territorial jurisdiction, because here the states are taking because here. So these both principles are examples of territorial principles where state is applying its own laws, own domestic laws to protect the citizen, to protect its own citizens, and where the wrong is committed, where the wrong is against either it's within the territory or it's against the nation, against the citizen of him, against one of the citizens of that state. How the nationality is considered, nationality could be determined of that person. It's generally based on two principles. One is based on blood, where the parents of the person is residing, that when the child born would have nationality or citizenship of that state only, or by birth, or by place, where the citizens of India are residing in the state of USA, and there the child was born, then the child would have the nationality of US itself. However, the child would have an option to decide of whom nationality he wants. So that's all about two of the principles. In my next video, I'll be discussing about other two principles of how the jurisdiction can be exercised by a state. Hope you like this video. Thank you.